Welcome back to the Deep Dive. Today we're focusing on a systemic challenge that really quietly undermines public trust, and it affects every single taxpayer in Tennessee. We're going to be diving deep into the urgent need to modernize the ethics laws that govern our constitutionally elected county officials.
And this isn't a problem that's, unique to one single jurisdiction, but we are using source material that focuses on Rutherford County. And that's because their recent history provides such a clear, almost a textbook example of the problem.
So what's the core issue here?
The central issue is that the current legal framework was, well, it was built for a completely different era. We're talking decades before digital records, before modern HR standards, or, the public's current expectation of absolute transparency. The old design is just failing modern county governance.
Right, so we're examining a crucial structural gap. We've seen controversies involving major county offices, the mayor, the property assessor, the circuit court clerk, the sheriff's office. And in these cases, the outcomes weren't really dictated by the seriousness of the allegations, but they were critically limited by the outdated laws themselves.
That is the mission of this deep dive. We are looking squarely at accountability, transparency, and the fundamental framework of the law, regardless of the individuals involved. This is about institutional integrity. It's not about partisanship or personalities.
Okay, let's unpack this.
So let's start by defining who we're actually talking about. In Tennessee, there are specific roles that are elected by the Constitution. They're not just appointed or created by the local county commission.
Okay, so who are they?
These are the county mayor, the sheriff, the trustee, the county clerk, the register of deeds, the property assessor, the circuit court clerk, and the clerk and master. That's 8 really powerful roles.
Wow, that's essentially the entire executive and judicial structure of the county. And I'm guessing this is where that structural gap you mentioned emerges.
Exactly. These 8 officials are not governed by the same code of conduct, and they're not subject to the same internal HR disciplinary policies as every single other county employee.
So they're exempt.
Correct. They are essentially miniature independent constitutional governments operating inside the larger county structure. They're exempt from local ethics policies. Legally, they answer only to state law and, ultimately the ballot box every 4 years.
But wait, isn't it true that part of the reason they're constitutionally elected is precisely to shield them from petty partisan squabbles with the county commission? I mean, isn't this lack of local HR oversight sometimes considered a feature, not a bug, designed to ensure they have independence?
Historically, yes, that was absolutely the intent. These offices were set up with statutory immunity to ensure that a potentially corrupt or partisan county legislative body couldn't just fire the sheriff or the property assessor if they disagreed politically. That independence is vital. But what was intended as political independence has created a kind of operational accountability vacuum.
So if a serious operational or ethical issue comes up, like misuse of staff or property or internal funds, the county commission can't intervene. HR can't start discipline, and the county attorney is, powerless.
Exactly. Any local ethics committee that the county sets up is limited to basically writing a referral letter, usually to the district attorney or the state controller. They just lack explicit enforcement authority over these specific constitutional offices because state law never granted it.
And that's the loophole.
That is the loophole that has allowed controversies to spiral out of local control. And it's the same framework that governs all 95 Tennessee counties. It makes this a statewide problem that we're just seeing through the sharp lens of Rutherford County's recent past.
Okay, let's look at how this accountability vacuum actually manifests, starting with the executive branch and the county mayor's office. County Mayor Joe Carr faced multiple ethics complaints, and these were serious allegations.
They were. Misuse of county staff time and property for non-county business. And those high-profile claims of retaliation against another elected official, property assessor Rob Mitchell.
And of course, the one specific anecdote that really captured headlines.
Oh yeah, let's not forget the misuse of county property for the sale of honey. Now, this wasn't necessarily the most egregious financial claim, but it perfectly symbolized the lack of a clear standard of conduct.
And the outcome here just tells you everything. 2 of the complaints were considered serious enough by the local ethics committee that they were referred to the district attorney, but several other complaints failed, specifically because the committee admitted they had no authority, no legal means, to enforce a local code of conduct against the mayor.
Right. The structural immunity basically provided a shield. The system could only refer the most serious claims to outside state authorities, but it couldn't resolve or internally discipline the bulk of the misconduct allegations. And that just left the public frustrated.
Okay, so shifting to the property assessor, Rob Mitchell. He also faced a complaint, which, a lot of observers believe was politically motivated retaliation. That complaint was referred directly to the comptroller's office and the DA.
In this case, irrespective of the merits of the allegations, it underscores the point just as well. Mitchell, as a constitutional officer, is exempt from the code of conduct that applies to his own employees. For listeners who might not know the structure, the Comptroller's Office in Tennessee is responsible for auditing and investigating the financial and operational integrity of local governments.
So when the county has no internal HR path, the issue just bypasses the local government entirely and goes straight to state investigators.
Precisely. The structural issue is that lack of a consistent, enforceable standard that applies to all constitutional officers.
And that structural weakness is, maybe most dramatically illustrated by the history of the Circuit Court Clerk's office under Melissa Harrell. That office faced not just one, but multiple highly publicized controversies.
Yeah, the first major incident was the 2016 conflict of interest scandal. The clerk's family operated a bail bond company, which state law explicitly prohibits a court clerk from having a financial interest in. The potential for self-dealing is massive.
And the breach was so severe that local judges, recognizing the conflict, had to recuse themselves from all bond matters. A senior judge had to be brought in just to revoke the family's license. That's a huge institutional shockwave.
It is. But the allegations didn't stop there. In 2021, lawsuits filed by former employees painted a really alarming picture of the office environment. The list included serious claims of wrongful termination, harassment, retaliation, and misuse of county computers.
Okay, here's where it gets really interesting for me. The sources detailed something pretty incredible. An unauthorized commissary business was allegedly operating inside the clerk's office itself. It sounds like something out of a TV show.
Yeah.
How is an operation like that even physically set up inside a government office?
Well, the mechanism is simple, but the lack of oversight is profound. If local county HR can't conduct physical audits, or implement discipline, or manage personnel because the elected official has statutory immunity, then unauthorized activities like running a side business can take root. Employees felt they had no path to local recourse against an elected official who, effectively acted as a micro-sovereign within her own office walls.
So once again, the local county government found itself unable to impose basic conduct standards or internal HR discipline because the circuit court clerk is a constitutionally elected official.
It just confirms that the structural problem is systemic, not an isolated incident. It applies across executive, judicial, and law enforcement offices.
Which leads us directly to the sheriff's office. As a constitutional office, it wields enormous independent authority, and this accountability vacuum has led to some dire consequences over several administrations.
We're talking about a history of significant turbulence. The county's ability to intervene or enforce internal standards has been limited, even when the resulting events attracted national attention.
Let's start with former Sheriff Robert Arnold.
Right. He was federally convicted for his role in an illegal, very complex jail-based scheme involving contraband e-cigarettes. This wasn't a county-level finding. This was a federal case.
He pleaded guilty to multiple federal charges, received a prison sentence, and resigned in disgrace. He even petitioned President Donald Trump for a pardon afterward. It's just incredible to think that someone sentenced to prison for a public scheme still had the independent status to petition the president. That's the definition of unchecked power until the feds step in.
And that unchecked power, or this local governance blind spot, it led to other failures, including the infamous Operation Candy Crush.
Ah, yes. The high-profile raids on local businesses selling alleged illegal CBD products.
That operation collapsed almost immediately. Charges were dismissed, businesses were cleared, and the actions were widely viewed as reckless and damaging to public trust. And the direct measurable cost of this limited local oversight was evident when taxpayers had to pay out significant funds for lawsuits and settlements filed by the wronged business owners.
And that's the direct consequence, right? When the local governing body can't impose reasonable conduct standards on its highest elected official, the failure to self-correct ends up costing the public massive amounts of money.
The pattern is consistent across all these offices. Lawsuits over jail conditions, deaths in custody, deputy misconduct, budget irregularities, transparency concerns. The sheriff is a constitutionally elected official, which means the county cannot impose conduct standards or discipline beyond the bare minimum required by state law. The issue is structural. It's not just about the personalities who happen to hold the office at any given time.
It's important, though, to maintain some perspective here. Not every constitutional office has been, mired in scandal. We see far fewer major public issues with the trustee, the register of deeds, or even the county clerk, who mostly handles routine operational matters.
That is an absolutely crucial piece of context. The goal here isn't an attack on specific offices or individuals. It's about creating a consistent, modern, statewide standard that applies equally to everyone entrusted with public authority and taxpayer money. The system should work just as well when there are issues as when there are not.
Because what the public deserves today is a system where misconduct has consequences, where ethics rules apply equally to the mayor and the janitor, and where oversight is consistent. And that system just doesn't currently exist for these 8 constitutional offices in any Tennessee county.
And that necessity is why a coalition of taxpayers, county employees, community leaders, and advocates is actively calling for change. They're demanding action from the Tennessee General Assembly.
So this is a legislative fix. It requires state intervention to empower local accountability. And the coalition has put forth 3 very specific demands in their petition.
Right. The first demand is the most direct. Grant county commissions the explicit authority to adopt and enforce clear codes of conduct for constitutional officers. This closes that statutory immunity loophole immediately.
And second,
Second, they want to align the ethical standards for all elected officials with the standards that are already applied to all other county employees. If the rules of conduct, discipline, and expectations apply to an HR manager, they should apply equally to the office holder they report to.
and finally, the broad goal is just to modernize ethics laws across the board and restore public trust. This isn't just about transparency, it's an essential overhaul for sound fiscal management.
Exactly.
But if the State General Assembly grants county commissions this new enforcement authority, what kind of safeguards would need to be in place to make sure a commission doesn't just use this power for political retribution? To punish an elected official they don't like?
That's a key question, and any serious reform legislation has to address it. The laws can't simply grant the commission the right to fire an official based on a political whim. Safeguards would likely require clear due process, ensuring any disciplinary action or removal goes through established procedures. Maybe a supermajority vote by the commission and a robust right to appeal the findings to an independent judicial or state administrative body. The goal is accountability for conduct, not vulnerability to political attacks.
Right, makes sense. Before we wrap up this deep dive, let's talk directly to the 3 groups who hold the power to implement or stop this change. First, to the county commissioners in Rutherford County and across Tennessee. You have publicly acknowledged that you lack the authority to enforce conduct standards on these constitutional officers. The coalition is asking you to stand with the public and formally request legislative action from Nashville. Your unified voice carries tremendous influence.
Second, to our Tennessee state legislators. You are the only ones with the power to fix this structural issue. Local commissions can't do it. The comptroller can only investigate after the fact. We are asking you to sponsor and support legislation that finally brings modern accountability and transparency to every county office in the state.
And finally, to every candidate running for local office in August, this is your litmus test. Pledge your support for modern ethics laws now. Put your name on the request for state-level action and show voters that restoring public trust and protecting taxpayer money is a commitment you make before you even take the oath.
And remember, modernizing ethics laws isn't about punishing individuals who made mistakes in the past. It's about protecting the institutional integrity of county governance and ensuring a consistent standard of conduct for the next generation of leadership.
So what does this all mean?
Well, if the county commission publicly acknowledges they lack the authority to enforce conduct standards, meaning they cannot step in when officials are accused of misuse of staff, property, or running unauthorized businesses, what stands out to you as the single biggest ongoing risk to taxpayer funds when no one at the local level can legally intervene? That knowledge requires you to actively engage with candidates regarding this specific legislative fix, demanding to know how they plan to close the loophole.
A powerful thought to chew on as you consider the local elections and the statewide consequences of this structural gap. Thank you for diving in with us.